Welcome to the Retzel Health Law Hotspot. Health Law Hotspot is a podcast for physicians and health professionals that covers the legal issues and trends that affect the healthcare industry.
Hi, everyone. Welcome to the Health Law Hotspot. I'm Erica Adler, shareholder, leader of the healthcare practice at Retzel and Andrus. I'm joined by Christina Kuda, who's also a shareholder and a member of our practice group. And today we're going to talk about a topic that comes up so often, and it has to do with patients who are engaged in social media and the rights of the practice and the obligations of the practice when it comes to allowing content to be recorded within the practice or otherwise participating in social media. So let's start first by just kind of talking about a couple of the scenarios where this is arising. What are you seeing, Christina?
So we live in a social media conscious world right now, and it has definitely hit the area of medicine and healthcare practices. What we have seen definitely proliferating over the last few months are a lot of requests from patients that want to video record procedures or video record interactions with their providers, and they want to post those videos to social media, whether it's to show, hey, I got this great new surgical procedure today and look how fabulous I look, or just to maybe educate people on certain health conditions. But it's definitely patient driven to want to record and then disseminate publicly these videos and information related to receiving healthcare services.
All right. So I know when a practice is doing its own social media and wants to take video or use photos of patients, we follow very serious protocols with patient consent and HIPAA, etc. But here we're talking about the opposite side. We've got patients asking to record. So what are the legal issues that we need to consider in this instance?
So HIPAA is still a huge issue. A medical practice cannot allow someone to record if that recording is going to expose or disseminate another patient's protected health information. If I'm a patient and I want to record, I control my PHI. I can consent to having my PHI disclosed. But you can imagine if I'm allowing a patient, if I'm a physician, to record in an office or, record when they come in the waiting room and, when they go back to the procedure room or an exam room, there's going to be other people on that video, all who are patients, and a face is someone's PHI. They can be identified. There may be, files or names outside of a room that describe who someone is or identify them in some way. Healthcare practices are full of PHI, and even though a healthcare practice has a duty to limit the availability and disclosure of PHI and the visibility of PHI, it's still there. Your name is called out in a waiting room. Those things are allowed because otherwise we wouldn't be able to have an operating healthcare practice. So PHI still is an issue. Another issue is consent to a recording, audio or visual. Some states are what we call two-party consent states, meaning that you just can't record someone if there's an expectation of some privacy. You can't just record someone, either video or audio, without their permission. So making sure that if you're going to allow a patient to record something, that anyone on that recording, either their face or their voice, will be consenting to that, and that consent is documented appropriately. Another concern is when information gets published. Again, we have patients that have requested that a lot of the practices we work with allow them to, record, and those patients want to publish that recording to social media. Even if protected information, HIPAA protected information is not recorded in a video, it's possible that the patient could be recording other information the practice wouldn't want disclosed, maybe proprietary business information or just general confidential information about their practice that they wouldn't want disseminated out to the public. So these are some of the, more significant considerations and legal issues with this type of activity.
Right. And I guess we also need to think about other employees in the practice. So you may the doctor may be asked to be on the video, but if, nurses or MAs or whatever are captured, they also need to consent. I mean, it's their
Absolutely.
name on there as well. And some people might be wondering, well, people videotape stuff and put it on social media all the time, videotape, showing my age there, record stuff all the time, out on the street, whatever. But there's a big difference between being out in public where you don't have a reasonable expectation of privacy and when you're in a doctor's office. And I think that's something that many average people who love to post everything on social media may not necessarily understand, even the difference between going into a restaurant versus being in a doctor's office, right? And those are important differences that, the average influencer may not be, understanding of.
Absolutely.
Right. Okay, so somebody comes in, they ask to be able to do this, or maybe you're just anticipating somebody's going to come in and ask to do this. What should practices be doing?
So the first thing I would say is establish a policy. Think about as a practice what your policy is on this and make sure it's reported to your patients. So the safest approach and the approach I personally recommend to clients is to have a no recording policy and to let patients know that there is no recording allowed in the office, in the practice. If you're going to allow them to record maybe their own medical interaction privately with the doctor, that's one thing, but there should be no recording in public spaces, hallways, waiting rooms, anything like that. Patients should be informed of your policy. You should post signage in waiting areas and treatment rooms explaining the policy in brief. So that would be the first thing to think about. If you're allowing a patient to record, again, their own interaction with a physician, make sure there's no visible PHI or anyone in the video hasn't consented. You want to make sure that there isn't a way where information about other patients can be overheard in the video. You really have to take steps to make sure that that video does not contain PHI or any other HIPAA protected or any other confidential information. If a patient wants to publish a video, one of the things I have had a few providers do in the past is request to view the video first to confirm what information is being published, confirm it's what was consented to be recorded, and to sort of double check that there is no PHI and there's no other confidential visible in that video.
Right. Now, that assumes every step of the way that patients are going to do the right thing,
Yeah.
which is talk to you ahead of time. Plenty of patients, record without permission, whether audio or video, and you may not even know they're doing it. Maybe something happened, in the room with the doctor. Maybe even they have a dispute at the desk when they're leaving about what they're being charged, and suddenly they're recording the whole interaction on video. I mean, these things happen all the time. What can be done at that point?
So if you find as a provider that someone has posted a recording of which you weren't aware or you think perhaps violates the law or confidentiality rules, I would reach out to the patient and ask them to delete and take down any recording. If you see a patient recording in the office and they don't have permission to do so, ask them to stop and delete the record. I'll tell you, oftentimes people will do that. They may not be happy about it, but they will do that. But there are times where you'll have patients that won't do that. They'll say they have a right to post it, or they, are, like you said, there's some dispute. They're mad at you for some reason and they want to not comply with a reasonable request. At that point, it unfortunately often becomes necessary to involve knowledgeable legal counsel who can help you navigate the legal system, which can actually compel someone to take down a video or to not record. If you have patients that refuse to comply, if they're coming in and they're saying, no, I want to record, and you say, we have no recording policy, it may be required for you to terminate that physician-patient relationship, of course, in a proper manner, making sure it doesn't constitute patient abandonment, but it may be necessary to have that patient not be part of your practice. If
You know,
HIPAA is breached for any of these issues, if you find that there was a HIPAA breach, somebody recorded something they shouldn't have, published it, and someone else's name is, another patient's name is in the video or something of that effect, you have to look at what HIPAA requires, and you may need to make requirements for breach notifications to the patients whose information was disclosed, or even the Office of Civil Rights related to a HIPAA breach.
now, one of the things that I think is true almost 100% of the time is that when you have patients doing sneaky things like this, recording without permission, especially if they know they shouldn't, and posting it, it is usually not something that is a positive post, right?
Right.
It is usually not something that is going to surprisingly bring lots of new patients and positive publicity to the practice. In fact, it is most likely something that is harmful to the practice, hurts its reputation, negative, often false, misleading, etc. And Christine and I have dealt with many of these cases, particularly a huge increase in the past year or two of patients either recording stuff in the practice and then later posting, or simply leaving the practice and posting information that's improper, misleading, blatant falsehoods. And, all of these involve situations where you really very quickly need to perhaps reach out to the social media site to get stuff taken down if the patient won't cooperate, and very quickly involve legal counsel to help, because reputational harm is a huge topic. We've covered it before on our podcast. We'll be covering it again because the number of cases is just exponentially increasing. And I feel like this topic, which is much more a collaborative topic, is still just on the fringe of the bigger problem, which is, people just doing things without permission to hurt a practice.
Absolutely. And I think, too, because we live in a society now where anyone can say anything about anyone else, whether it's truthful or not, and disseminate that truth or untruth very broadly and quickly, the healthcare industry is sort of seeing the downside of that, unfortunately. And unlike other industries, like if somebody goes on social media and says they had a horrible, checkout experience at Target, Target could come back and say, well, this is actually what really happened here, and you're lying about the interaction. That can't happen in a healthcare business because of HIPAA constraints and confidentiality laws. Practices aren't allowed to just come back and say, no, this person's lying. Let me tell you exactly what happened. And unfortunately, we also live in a society where people are quick to believe people without, thinking about whether someone is telling the truth or not, or not having any evidence to support what they're saying. So, we are definitely seeing issues with physicians who have people that have, for whatever reason, decided they want to harm their business and want to hurt their reputation, and have blatantly made up information or twisted information to make it look very bad for a healthcare provider. That's, impacted the healthcare provider's practice. And there's not so much that can be done about it, although there are some legal avenues. And as you've indicated, we've discussed that in some prior podcasts. And I know, as we move forward, we'll have some more discussions about what practices can do if they do experience an issue of reputational harm.
Right. All right. So, on this topic of allowing patients to record in the practice, is there anything else you want to add?
Yeah, one of the things I would consider is, if you're going to allow patients to record, even their own interactions, you'd maybe want to check with your malpractice carrier to see what their opinion is, and see if there's any prohibitions on doing that, or if they have any recommendations not to allow that. You can envision a scenario where a patient wants to record and maybe something happens that wasn't necessarily the standard of care. There's an issue, and now you have a recording of something that maybe you initially wouldn't have wanted recorded. So your malpractice carrier may have some advice for you. I know there's some practices, particularly aesthetic medicine practices, that see this to some extent good publicity for their practice, because they're changing people's looks or appearance, hopefully for the better. And social media influencers can reach a lot of people and can actually sometimes be helpful to a business. So, if you're considering that in certain type of medical practice, I would really think about the potential legal implications. And like you indicated, Erica, if the patient gets mad at you for some reason, there's a bill they received, they didn't think it was going to be that much money, and now they want to try to, use a video in a way that was intended to be used positively and now is going to be used in a negatively as a weapon. Those are things that you want to consider before you think that social media would be helpful to your reputation.
Right. Absolutely. And so, lawyers can really help you kind of frame those relationships with patients. If you do want to let a patient go in and record, consider a written contract maybe between the parties explaining when it can be used, how it can be used. As Christina mentioned, being able to see it before it's put out there, that there can't be any later editing that might twist things around, etc. Exactly in line with what Christina just mentioned. So there's a lot to think about. This is a really interesting topic. And as social media continues to grow, if it can grow any more than it has, and impact medical practices in particular, this is a topic that we expect to come up frequently. So, all right. Well, thanks for joining us. If you have any questions, please feel free to reach out to me or Christina. And this has been the Health Law Hotspot. We'll see you next time.
The Retzel Health Law Hotspot is made available by the firm and its attorneys for educational purposes and to provide general information, not to provide specific legal advice. Use of the Retzel Health Law Hotspot does not create an attorney-client relationship between you and the firm or any of its attorneys. The Retzel Health Law Hotspot should not be used as a substitute for competent legal advice, and you should contact an attorney in your state about any legal needs or questions you may have.